For over a century, the Bill of Rights was basically a souvenir. States could censor newspapers, search you without a warrant, and strong-arm confessions. The Supreme Court's response? Looks fine to us. So how did these lofty promises on paper transform into the ironclad shield we use today? The story involves 3 post-Civil War amendments, 1 butchered Supreme Court case, and a stubborn band of lawyers who refused to quit. Section 1, the glory days that weren't. We imagine James Madison handing out freedoms to high-fiving colonists, but that's a fantasy. In 1791, the Bill of Rights only restrained the federal government. If your state decided to ban a religion or search your home, the Constitution just shrugged. States had their own rules, so nobody thought the Federal Bill of Rights mattered in their daily lives. For nearly a century, they were right. Local sheriffs and state legislatures often just ignored those lofty phrases about life, liberty, and property. To Section 2, the 14th Amendment's big promise. Fast forward to 1868. After the Civil War, Southern states passed black codes to control newly freed slaves. Furious, Congress fired back with the 14th Amendment. It granted citizenship and ordered states not to deny citizens their privileges or immunities, due process, or equal protection. In plain English, it sounded like states finally had to respect basic rights. But in the 1873 slaughterhouse cases, the Supreme Court decided this new amendment meant almost nothing. The justices ruled the Privileges or Immunities Clause only protected narrow federal rights, like using a U.S. port. Your right to free speech or a fair trial. The court said those were state privileges, and local governments could do as they pleased. A single opinion gutted the 14th Amendment before it could even breathe. Section 3, 100 Years of Shrugs. With slaughterhouse on the books, states became constitutional free fire zones. Governments could segregate public spaces and extract forced confessions with impunity. By 1900, the Supreme Court had applied only one right against the states, the rule that the government must pay you if it takes your property. This was great if you owned a tugboat in Washington, D.C., but useless for a black farmer in the Jim Crow South. For most Americans, the Bill of Rights might as well have been written in disappearing ink. Section 4. Enter the ACLU and the courtroom slog. But then, things changed. In 1920, the American Civil Liberties Union, or ACLU, was founded with one mission: make the Bill of Rights real for everyone. Their strategy was grueling: find a blatant violation, fight it in court, lose, appeal to the Supreme Court, and repeat. The breakthrough came in 1925 with Gitlow versus New York. A socialist named Benjamin Gitlow was jailed for distributing a pamphlet. The ACLU argued this violated his First Amendment right to free speech. For the first time, the Supreme Court agreed. They ruled the 14th Amendment's Due Process Clause incorporates, or applies, free speech protections against the states. Over the next 4 decades, advocates fought, case by case, for freedom of the press, religion, and assembly, slowly persuading the court that basic rights had to be national. Section 5, the 5th finally arrives. Perhaps the biggest prize was the 5th Amendment's protection against self-incrimination. This came to a head with Ernesto Miranda, a man arrested in Phoenix and questioned for 2 hours without a lawyer, leading to a coerced confession. In 1966, the Supreme Court's bombshell ruling in Miranda versus Arizona fundamentally reshaped policing. It required officers to inform suspects of their right to remain silent and their right to an attorney. The phrase, "you have the right to remain silent," became a part of pop culture overnight. By 1970, this relentless legal battle had grafted nearly every key part of the Bill of Rights onto the states, protecting ordinary citizens. How does this history matter now? Just look at today's headlines. Debates over free speech online, digital privacy, and state laws on personal liberty all trace back to one question: does the 14th Amendment force states to respect the Bill of Rights? The fight isn't over, it's just on new battlefields. And the next big Supreme Court case could rewrite the rules all over again. Section 6. Why the wait took so long. Why did this take a century? 3 reasons. First, the disastrous slaughterhouse precedent terrified judges for decades. Second, the court believed in local experimentation, letting states set their own, often unequal, levels of liberty. And third, most Americans didn't know their state could deny them rights the federal government couldn't. It wasn't until industrialization, world wars, and mass media shrunk the country that uniform rights seemed essential. Then, when images from the civil rights movement, like police dogs attacking peaceful protesters, flooded the nation's living rooms, the phrase "states' rights" was exposed as a cover for brutality, and the Constitution finally began to catch up. Section 7, the Bill of Rights today. Today, the Bill of Rights shapes debates on everything from social media content to smartphone privacy. Yet, incorporation remains selective. The Third Amendment's ban on quartering soldiers and the Fifth's requirement for a grand jury indictment still don't apply to the states, mostly because there haven't been compelling modern test cases. Meanwhile, new technology forces new questions. Does the Fourth Amendment protect your phone's location data? Does the First Amendment cover social media algorithms? The answer to every new question hinges on that same legal test established back in 1925. Is the right fundamental to ordered liberty? So the next time you hear an officer on TV say, "You have the right to remain silent," remember, that right is younger than commercial air travel. For a century, the Bill of Rights was a dusty ornament. Its transformation into a living document wasn't inevitable. It took the post-Civil War amendments, decades of courtroom defeats, and the stubborn grit of lawyers and ordinary citizens who looked at that old parchment and said, "This should work for me." This is the critical lesson. Rights that are ignored go dormant. They only stay alive when they are fiercely demanded. Landmark cases like Miranda v. Arizona or Brown v. Board of Education didn't start in Washington. They started with everyday people. America's most cherished rights were once useless, and they can become that way again if we assume they're permanent. The parchment doesn't enforce itself. We, the people, do.